Because what I'm about to say may be received as controversial by some people, including my peers and colleagues, I'm going to preface this dirty little secret with a couple of things. First, I love my job. I love being a lawyer. Not much feels better than leaving a mediation session or a courtroom after trial and knowing that what you did improved the quality of life for your client or for your client's family. It's a great job. I'm thankful to be able to do what I do. Second, much of my criticism is aimed at law schools and legal education. Law schools fail law students and lawyers for a couple of reasons. One, they tell us going in that they are going to prepare us to be lawyers. And two, they tell us when we graduate that they have done that. And neither of those things are true. But the biggest problem I have with that is they know it's not true. They know it's not true when they tell us at the beginning, and they know it's not true when they tell us at the end. I'll spare you the long version of this story, but back in 1870, the dean of Harvard Law School made a conscious decision to exclude skills training from law school. And then because it was Harvard, all the other law schools followed, and they have not changed in 150 years. Back in the early 1970s, a Chief Justice of the United States Supreme Court, Chief Justice Burger, went to England. He saw how good the lawyers were there from top to bottom, and he was shocked. He was absolutely blown away. He gave a big speech about it that was later published in a law review, and a special committee was formed to investigate this. They went back, found that 1870 was the critical year for change in law school, and then nothing happened. So it's a problem, but we all have to deal with it. I had to deal with it early on. I realized, wow, I am unequipped and unprepared to do a lot of this job that I've been told I'm ready to do and that my clients are paying me money to do. So I went and found skills and development training, and I continue doing that to this day. But in that process, I learned some dirty little secrets. This video relates to some of my other work, writings, and another video, especially one I call The Process, that's about our proprietary process and our philosophy and approach to handling a case for a client. So when I'm talking to a client, when I'm talking to a colleague, when I'm talking to anyone about these topics, I tend to use some of the same graphs and artwork over and over again. I've got this for you. You've seen this in the process. I did it by hand there. And anytime I'm meeting with a potential new client or a client, you are always here. This square represents resolution. Cases are resolved only one of two ways. It is a binary option, settlement or trial, and you don't have complete control. You can try to settle. You can make a settlement offer. You can think, this is reasonable. I'm giving up a lot to try to get this done. And the other side says, no, I don't agree. Then you are headed to trial, even if you don't want to be. That's just the way it is. That's in the other video. This curved line represents the flow of information over the course of a lawsuit. So when you come and meet us, you are always here. We need information. We need you to help us gather information. We need to assess it, evaluate it, and we need to produce it to the other side. There are special rules requiring disclosure of information, voluntary disclosure, even if the other side has not asked for it. There is a rule of evidence that corresponds to that says if you try to present evidence at trial and you haven't shown the other side, you withheld it in discovery, you withheld it from your disclosures, you withheld it in this litigation timeline, this pretrial process, then you may not be able to use it in trial. It can be excluded because you're not supposed to be able to ambush people. So there's a discrete skill set between this pretrial litigation process and trial. They are different. They are somewhat related because, especially if you follow our philosophy, you are working towards resolution, whether that's settlement or trial. But trial is something different. Trial is more about facts than law. This is a mix of assessing the case from a legal perspective and from a factual perspective. But in trial, we call witnesses. We present evidence through testimony and documents and tangible things like exhibits. And so our witnesses are called fact witnesses for a reason. They're there to deliver facts, and we are trying to get a decision maker, a judge or a jury, depending on the type of case, to rule in our favor. That requires good, clear communication, that requires good preparation, it requires conversational skills, things that aren't necessarily the same as what we did before trial in discovery, issuing subpoenas, sending requests for information to the other side, and making exclosures, settlement offers, negotiating. Those are all different. Those things don't happen in trial. In trial, everybody is supposed to know who are all the witnesses and what are all the exhibits. So trial is something else. They are related. So law school does not teach this skill. They do not teach us how to try a case. I'll give you a quick example. A man I know locally, right out of law school, he was a non-traditional law student. He came in, he was older than most of his colleagues in his law school class. A few years after law school, he is winning some extraordinary verdicts. He's getting acquittals in murders where the weapon is found in his client's hand. He's just getting some outstanding results. So I go and have a conversation with him. I want to know what's going on. What is different? Did he get something in law school that I didn't and that many people I know did not get? What I learned was this. Before law school, he worked in sales for a mega corporation, and they spent tens and hundreds of thousands of dollars investing in him to give him strong sales communication skills. So he brought that into law school. His knowledge of the law and his knowledge of the litigation process is the same as the people he went to law school with, but his big advantage and differentiator is he is very likable. He's very conversational and persuasive. You want to rule in his favor, and that's how he's able to do things that the other people in his class from law school are not able to do. They do not understand, and that's because somebody else invested in him prior to the legal education. The dirty little secret is this. Evidence has to be disclosed in discovery, but something that's produced in discovery is not necessarily going to be evidence. On this curve, we're trying to sort out of a bunch of information what is usable and what is not. So there's a lot of discards. Okay, so our philosophy includes keeping our eye on the ball for resolution, not just trial, but for settlement. What are we getting in this information from our client and this information from the other side, information from third parties that's going to add value to the case? And what do we not have that may be out there that we can get by a subpoena or a discovery request and add value that will lead to a favorable outcome? Law school teaches us how to do some of this. They teach us how to write big, flowery motions and how to send subpoenas and how to just discover the heck out of a case. They're not really teaching us how to make a connection between those requests and that information and the ultimate outcome. So what you end up with is a population of lawyers who are really skilled at making requests for information, obstructing the flow of information by filing these really verbose, heavy objections to discoverable information, and they're billing the whole time. Most of the time, the only winner in a discovery dispute, the only winners are the lawyers. And I'll tell you another story. I'm going to court. I have a hearing. I get there 15 minutes early, so I see another hearing in front of me, and it's a discovery dispute. And I'm only there for a few minutes, but what I learn is what the judge is learning at the same time, and that is these people had reached a partial agreement, and part of their agreement was that there was going to be another set of information in the future that each side would have ready access to. It would be disclosed, income information. And one side was there with his lawyer objecting to that, saying, now we don't want to do that. That was extreme. That wasn't what we meant. That is not relevant. We should not have to produce it. And this lawyer did everything you can imagine, things that you may only see on TV. He did a little dance. He sang a little song about how extreme this is. He engaged in hypotheticals about what if this, what if we produce it and they don't think it's enough, or what if next year they ask for more. He went on and on and on in the ways that only a lawyer can do. And when they left that hearing, his client left with an order to produce all of that information. And there was only one winner that day, and that was the lawyer who got paid for that little circus act that he did about information that was going to have to be produced. This is a hard thing to sell because it involves some paradoxes that you have to think through. And one is, the big one I think is, we may have to produce and we may have to request information that we ultimately don't use. So we're constantly trying to be efficient and weigh cost benefit. Do we really need this? If we get this and it says what we think it might say, will we use it at trial? And if the answer to that question is no, then what are we doing? You need to be able to make a connection between what you're asking for, what you're doing, and the possibility of using it at trial, even though you know you don't have a crystal ball and we may get it and see, okay, it's not really usable like we thought it was going to be. And you have to understand that the rules of discovery are more broad than the rules of evidence. Like I said, there's a disconnect between the work lawyers do prior to trial and at trial, and there's a disconnect in the rules and the law. The evidentiary rules for relevance are tighter at trial than they are in discovery. So information may be requested that everybody can see this is really unlikely to be used at trial, but you may still have to produce it. So that's where lawyers are skilled at getting in that gray area and perpetuating a case. Well, we don't have this, we don't have that. And they're talking about information that is technically discoverable, but there's never a connection made to, we need this because of what is going to happen at trial or mediation. That connection is never made. And what I tell clients is that any lawyer, a month out of law school, can spend $20,000, $40,000 of your money on a discovery dispute that will add zero value to your case or to your life. And I think it's a mistake to do that. So you have to be involved and participate in your case. Talk to your lawyer and ask questions. Why are we doing that? And you need answers. How does this connect to trial? Or even if it's a request from the other side that you and your lawyer both agree, this is really not going to amount to a hill of beans at trial, should we still produce it because it's discoverable? Again, the standard in discovery is not, is it admissible at trial? It's a different standard, is it discoverable? So you have to weigh the cost-benefit analysis of fighting a fight and going to court. And even in that extreme example of the lawyer singing a little song and doing a little dance, you may end up producing that information in a way, and you're going to waste a lot of money, and you're going to waste it on a lawyer who gets paid either way.